Hello and welcome once again, this time to the presentation for Module 10, the hearsay rule. I'll be talking today about the rule itself, some common law exceptions, and some statutory exceptions. The one topic we will not be discussing under this area is confessions. And although confessions can be considered to be hearsay, we will have already discussed those in another lecture. Let's start with some definitions from the rules. Federal Rules of Evidence provides that a statement is a person's oral assertion, written assertion, or nonverbal conduct if the person intended it as an assertion. So gestures can be hearsay if they are intended to be interpreted as conveying a message, such as nodding one's head, pointing at something, or gesturing. A declarant is a person who made the statement. Hearsay itself is a statement that the declarant does not make while testifying at the current trial or hearing, and that a party offers in evidence to prove the truth of the matter asserted in that statement. Statements that are not hearsay are statements that meet the following conditions in the rule. A declarant witnesses prior statement. The declarant testifies and is subject to cross-examination about a prior statement, and the statement is inconsistent with the declarant's testimony and was given under penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. Again, keep in mind this is not necessarily hearsay because it's really cross-examination to attack the credibility of the witness, in that with respect to the same topic, they've made two separate statements that are not the same, and both statements have been made under oath. That the statement is declarant with the declarant's testimony and is offered to rebut an express or implied charge that the declarant recently fabricated it or acted from a recent improper influence or motive in so testifying. So if a person's challenged that they've changed their testimony, or it's been made up at a later date, or has been pressured later on to change their testimony, that statement can be used to confront that declarant with respect to the current testimony they're offering. It's not hearsay, however, because it's not being used to establish the truth of the testimony that the declarant's being confronted with, but to establish other circumstances surrounding the making of an earlier statement as opposed to the testimony that's currently being presented. Now, if under B, the declarant adopts the earlier statement, then it is no longer hearsay and can be admitted on the merits, because the witness has adopted the earlier statement as being a statement that they made. Now they're subject to cross-examination not only on the current statement, but the prior statement as well, because now it's in evidence. The subparagraph C is that the statement identifies a person as someone the declarant perceived earlier. An opposing party statement. If a statement is offered against an opposing party, it's not hearsay if it was made by the party in an individual or representative capacity, is one of the party manifested that it adopted or believed to be true, was made by a person whom the party authorized to make a statement on the subject, and this could be an agency situation for that matter, was made by the party's agent or employee on a matter within the scope of that relationship and while it existed. And now we're getting into the realm of attorney comments on behalf of their client sometimes, and statements made earlier in a trial, for example, or was made by the party's co-conspirator during and in furtherance of the conspiracy. And that has generated, this particular exception has generated a whole substance of hearsay litigation. The statement must be considered but does not by itself establish the declarant's authority under C to make the authorized statement. The existence or scope of the relationship under D, that has to be proven separately, or the existence of the conspiracy or participation in it under E. That also, the existence of the conspiracy has to be established before any testimony can be offered under category E. The rule against hearsay. Hearsay is not admissible unless any of the following provides otherwise: a federal statute, the federal rules of evidence, or other rules prescribed by the Supreme Court. And in this case, it's the United States Supreme Court, because it's a federal rule that we're talking about. Now, some exceptions to the rule against hearsay, and this is regardless of whether the declarant is available as a witness. You'll see later on some of the hearsay exceptions require that the declarant be unavailable to testify as a witness. In this case, under 803, it doesn't matter whether the declarant is available or not. These 23 enumerated exceptions to the federal hearsay rule are based in large part upon hearsay exceptions that existed at common law. And the common law we're talking about is up through and including the current common law that has been produced as a result of litigation after 1776 and after 1789, the adoption of the United States Constitution. According to these comments, these exceptions originally evolved through trial and error as being those which, under the factual circumstances, indicated no motive to lie or fabricate the statements. In other words, they each have an inherent indicia of trustworthiness. These exceptions are present sense impression, and that's they're talking about, well, it's cold in here. That's a present sense impression, for example. It's dark in here. It smells in here. It's wet in here. Those kinds of things. Excited utterances, a statement that someone makes while they're under the immediate influence of some event that they are perceiving. Oh my God, he ran the red light. That's an excited utterance. He just tried to kill me. I've been shot. Things like this. Those are excited utterances, and they're made without an opportunity for the declarant to make it up. There's no opportunity to think about what they're saying in a very realistic way. They are responding verbally to an experience that they are perceiving or have just immediately perceived. Then existing mental, emotional, or physical condition. Someone can testify about how, or their statement can be used, whether or not they're available, as to how they felt, how they were feeling. I was sad, I was upset, I wasn't thinking straight. Or a physical condition. My side hurt. I injured my knee and I had to limp and it hurt. Statements made for medical diagnosis or treatment. Now this is a well-recognized current exception to the hearsay rule, at least, because a person is not likely to lie to a physician or a medical practitioner for the purposes of them making a medical diagnosis and or establishing a course of treatment. It doesn't necessarily mean it's correct, but it's trustworthy, because doctors routinely, and hospitals and physicians and nurses routinely adjust a person's diagnosis and their treatment under that diagnosis based upon statements that a patient is making to them. This also includes medical history as well. Recorded recollection. All right, now we're into the area of recollection recorded versus present recollection revived, and that, of course, will be discussed in another module. Business records, records of irregular activity. It's the business record exception, and typically these are admitted, subject, of course, to challenge and cross-examination if the books have been cooked, as they say. But it's records of regular business activity showing receipt of goods for sale or other business transactions. the absence of a record of a regularly conducted activity. The fact that this business is in the habit of keeping a record of certain events, and the absence of such a record in a timely fashion indicates that it didn't occur. And, for example, a person declares that they were born in a state, let's say Hawaii, and a review of the Hawaii birth records indicates that such a record is not present. That's admissible to show that potentially the event didn't occur. Public records, okay, we're talking now about ordinary records that a state keeps in the course of conducting its business. 9, public records of vital statistics. Now we're back into the birth certificate area as well, but deaths, marriages, and the like, naturalization ceremonies, again, and birth records. Also under this rule is an exception for the absence of a public record. And, of course, that can be admitted into evidence to show that an event that should be recorded in a public record didn't actually occur, at least with respect to that particular public agency. Number 11 is the records of religious organizations concerning personal or family history, and exception 12, certificates of marriage, baptism, and similar ceremonies sort of go hand in hand, because this is a catch-all for religious organizations and other types of ceremonies that might not necessarily fall within the scope of a public record, at least for genealogical purposes, for establishing rights of inheritance, and so forth. So these come in as essentially business records under the same context. Number 13, family records. These are records that encompass recordings, for example, of family events, marriages, and deaths in the family Bible. And these family record exception is certainly directed to that kind of information, although it's not something that occurs in today's lifestyles very often at all, but nonetheless, that is a vestige of that practice. 14 and 15 are sort of taken together, and they are records of documents that affect an interest in property and statements in documents that affect an interest in property. And that could be a will that has not been probated, that has not been filed for probate, that has not been filed for safekeeping with a Register of Wills office. It could be found in a decedent's bedroom bureau. So long as it's duly executed under the laws of the particular jurisdiction, those records are admissible to show that, for example, a person wrote a will and made certain bequests. Also that the person executed a deed or received a deed or a lease or an easement that hasn't been recorded in the land records in the appropriate county. The failure to record such a document doesn't affect its ultimate legal effect. It does, however, have some statutory prohibitions with respect to notice, but it doesn't actually affect the ultimate disposition. And statements in the documents, I give 1/3 of my property, real and personal, to my son Harry. That's an admission that Harry is this person's son. So for not only inheritance purposes, but for other purposes as well, this is now an admission of paternity if it's never been done before. Statements in ancient documents. Now, the ancient documents rule used to be 30 years, but in some states, such as Florida, it's 20 years, which means if a document has been in existence that affects people and it's remained unchallenged, as I said, it used to be 30 years, and then in some states it's 20 years. If it has remained unchallenged for 20 years, it is at least presumed prima facie to be correct. It's subject to challenge, of course, but nonetheless, it is evidence which establishes an issue that the opponent then has to address and negate. Those documents are admissible to prove their contents, the statements and the contents. And And this is separate from documents that affect an interest in property or wills and trusts, for example, because documents themselves in that earlier example have their own independent legal effect, whereas statements in ancient documents are merely documents used to establish a fact. They do not carry independent legal weight other than their evidentiary value. Market reports and similar commercial publications and the stock market quotes for a particular day for the valuation of stock, for example. So those are admissible to establish what stock values were on a particular day for a particular company, for example. Statements in learned treatises, periodicals, or pamphlets. This isn't utilized a whole lot anymore, but it can be used to establish some principles of law, for example, to establish some, especially with the periodicals. Journal articles, for example, are encompassed here, and these documents are admissible on their own face for whatever weight that a jury or a trier of fact may give. Pamphlets, for example. There may be statements in pamphlets that somebody's handing out on the street corner that may be important later on. These can be used in favor of a position or against it to show that, for example, the pamphleteer was lying, passing out libel, slanderous material. Reputation concerning personal or family history. Anyone who is familiar with it and can be shown to be familiar with it will be permitted to testify with respect to the reputation in the community with respect to and or reputation in a family. It can be admitted to show or to establish or to negate the existence of some event or occurrence. Reputation concerning boundaries or general history. Now this, we're back into real property. We don't seem to have this problem too much anymore because most property is now surveyed. But in the earlier days, boundaries very often were fixed by physical items such as a stream, a tree, a wall, a fence, a barn, a road, and prior to having been surveyed. And I come from Maryland, where there were properties that I'm aware of that had never passed out of the family's hands and were descended from one person to another, and there was never a deed issued. I have a friend who's holding property under a land grant from King Charles. There's never been a deed issued on that property, and it's never been surveyed. So it is the boundaries that are described by physical characteristics that establish where the property really is. And I worked my way through law school as a surveyor, and we used these kinds of documents and this reputation for the description of property to establish starting points for property surveys sometimes. Number 21, reputation concerning character. Again, this has to be based upon the reputation in the relevant community, and it's got to be someone who is shown to be in a position to make that kind of an assessment. And again, it's subject to cross-examination. Judgment of a previous conviction. Of course, these are court records, and they usually come in under the public records exception, but nonetheless, they are admissible to prove the contents of the document. Judgment is involving personal, family, or general history or a boundary, and these are court documents that establish a divorce, for example, or personal liability under a judgment, or general history of an issue, or again, a boundary that has been declared to exist by a court exercising proper jurisdiction. 804 are exceptions when the declarant is unavailable, and this is an absolute requirement. A, criteria for being unavailable. A declarant is considered to be unavailable as a witness if the declarant is exempted from testifying about the subject matter of the declarant's statement because the court rules that a privilege applies. So if a person asserts a privilege, and is entitled to assert that privilege, they are, for all practical purposes under the hearsay rule, unavailable as a witness. We've talked earlier about persons who refuse to testify under a privilege when we've discussed privileges, and you have to read that in this context with respect to paragraph A1 here. Declarant also, if they refuse to testify about the subject matter despite a court order to do so, and they can be ordered under contempt if there's no privilege, but any statements that they've made in the past or documents they possess are admissible if the provenance of these records can be established, and they are considered to be unavailable. Or an individual who testifies to not remembering the subject matter. Any document or statements they've made may be used to prove that they made a statement. It cannot be present or to testify at the trial or hearing because of death, in other words, the person themselves died, or then existing infirmity that were prevented because of a current medical condition, physical illness, or mental illness, or is absent from the trial or hearing, and the statement's proponent has not been able by process or other reasonable means to procure the declarant's attendance, in the case of a hearsay exception under B1 or 6, or the declarant's attendance or testimony in the case of a hearsay exception under B2 and 3 or 4. Now, this covers the exceptions we're talking about now under this rule. Subsection A does not apply. This is important, ladies and gentlemen, does not apply if the statement's proponent procured or wrongfully caused the declarant's unavailability as a witness in order to prevent the declarant from attending or testifying. Now, this is a very narrow exception, and it is only called into play when the opponent of this evidence actually does an act which is intended to prevent the witness from testifying in the proceeding that is currently before the court. So simply because you murder someone doesn't make this person unavailable for under this exception anyway. But if you've murdered them to keep them from testifying, that's a different story. Or if you've bribed them or threatened them or their family to keep them from testifying, they are considered to be unavailable under this rule, and hearsay will be admissible. A statement offered against a party that's wrongfully caused or acquiesced in wrongfully causing the declarant's unavailable as a witness and did so intending that result. And that's what I've just commented on. Residual exceptions. In general, under the following circumstances, a hearsay statement is not excluded by the rule against hearsay, even if it's not specifically covered. The statement has equivalent circumstantial guarantees of trustworthiness, is offered as evidence of a material fact. It is more probative on the point for which it is offered than any other evidence that the proponent can obtain through reasonable efforts, and admitting it will best serve the purposes of these rules and the interests of justice. In a few moments, I'm going to be talking about a Supreme Court case and its impact on some of these hearsay rules. And this case sharply limits the scope and the admissibility of hearsay under some certain circumstances. So there is a superintending Sixth Amendment right to confrontation issue in criminal cases, not in civil cases, only in criminal cases. And these statements that we've been talking about with respect to the residual hearsay is the statements admissible only if, before the trial or hearing, the proponent gives an adverse party reasonable notice of the intent to offer the statement and its particulars, including the declarant's name and address, so the party has a fair opportunity to meet it. In other words, enough information to object to it or to propose countervailing evidence. The Sixth Amendment's Confrontation Clause provides that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. And in the case of Pointer versus Texas, the Supreme Court stated, "We have held that this bedrock procedural guarantee applies to both federal and state prosecutions." In a later case, in Ohio versus Roberts, the court said that an unavailable witness's out-of-court statement may be admitted so long as it has adequate indicia of reliability. That is, it falls within a firmly rooted hearsay exception or bears particularized guarantees of trustworthiness. Subsequently, the Supreme Court, in a case in 2004, rejected the particularized guarantee of trustworthiness test for the admissibility of testimonial evidence. In Crawford, the court introduced into the criminal law under the Sixth Amendment Confrontation Clause the concept of testimonial hearsay, and this has tempered the admissibility of some of the generally recognized hearsay exceptions. The Crawford case actually involved an individual who was charged with assault and attempted murder. The trial court allowed the state to play for the jury a tape-recorded statement in which the accused's wife, who, because of the state marital privilege that generally barred one spouse from testifying against the other without the other's consent, did not testify at trial, and the statement was taken during the police interrogation, and it described the accused stabbing of the victim. The jury convicted the accused of assault, and the Washington Court of Appeals determined that the wife's statement did not bear particularized guarantees of trustworthiness and reversed. The Washington Supreme Court, on the other hand, reinstated the conviction and concluded that the statement was reliable because it was nearly identical to, that is, interlocked with, the accused's own statement to the police, and reinstated the conviction. On a writ of certiorari, the United States Supreme Court reversed this conviction and remanded. On August 5th, 1999, Kenneth Lee was stabbed at his apartment. Police arrested the petitioner later that night. After giving the petitioner and his wife Miranda warnings, detectives interrogated each of them twice. Petitioner eventually confessed that he and his wife had gone in search of the victim, Lee, because he was upset over an earlier incident in which Lee had tried to rape her. The two had found Lee at his apartment, and a fight ensued in which Lee was stabbed in the torso and the petitioner's hand was cut. The wife's statement during the police interrogation essentially corroborated the defendant's story, but her account was arguably different with respect to whether the defendant had drawn a weapon after the victim Lee had drawn one or before. The U.S. Supreme Court concluded that the right to confront one's accusers is a concept that dates back to the Roman times. The founding fathers' generation, the immediate source of the concept was the common law. English common law has long differed from continental civil law in regard to the manner in which witnesses give testimony in criminal trials. The common law tradition is one of live testimony in court subject to adversarial testing, while the civil law condones examination in private by judicial officers. In any event, by 1791, the year the Sixth Amendment was ratified, courts were applying the cross-examination rule for confrontation even to examinations by justices of peace in felony cases. Parliament subsequently amended the promissory statutes to make the requirement of confrontation clear. John Adams, one of the framers of our Constitution, while defending a merchant in a high-profile admiralty case, argued that examinations of witnesses upon interrogatories are only by civil law. Interrogatories are unknown at common law, and Englishmen and common lawyers have an aversion to them, if not an abhorrence to them. All of this history supports two inferences about the meaning of the Sixth Amendment. First, the principal evil at which the Confrontation Clause was directed was the civil law mode of criminal procedure, and particularly its use of ex parte examination as evidence against the accused. The Sixth Amendment must be interpreted with this focus in mind. Accordingly, the Supreme Court said, we once again reject the view that the Confrontation Clause applies of its own force only to in-court testimony, and that its application to out-of-court statements introduced at trial depends on the law of evidence for the time being. This focus also suggests that not all hearsay implicates the Sixth Amendment's core concerns. An offhand overheard remark might be unreliable evidence and thus a good candidate for exclusion under the hearsay rules, but it bears little resemblance to the civil law abuses of the Confrontation Clause, which targeted against these types of statements in criminal proceedings. Confrontation Clause therefore applies to witnesses against the accused, in other words, those who bear testimony. Various formulations of this core class of testimonial statement exist. Ex parte, in-court testimony, or its functional equivalent, that is, material such as affidavits, custodial examinations, prior testimony that the defendant was unable to cross-examine, or similar pretrial statements that declarants would reasonably expect to be used prosecutorially. And that's the key here. Statements pretrial that the declarants would reasonably expect to be used prosecutorial. And this has been further described as statements that were made under circumstances which would lead an objective witness reasonably to believe that the statement would be available for use at a later trial. These formulations all share a common nucleus and then define the clause's coverage at various levels of abstraction around it. Regardless of the precise articulation, some statements qualify under any definition, for example, ex parte testimony at a preliminary hearing. Statements taken by police officers in the course of interrogations are also testimonial under even a narrow standard. Police interrogations bear a striking resemblance to the examinations by justices of the peace in England. The statements are not sworn testimony, but the absence of the oath is not dispositive. Even if the Sixth Amendment is not solely concerned with testimonial hearsay, that is its primary object, an interrogation by law enforcement officers falls squarely within this class. The right, thus, to be confronted with the witnesses against him is most naturally read as a reference to the right of confrontation at common law, admitting only those exceptions established at the time of the founding. As the English authorities reveal, the common law in 1791 conditioned admissibility of an absent witness's examination on unavailability and a prior opportunity to cross-examine. The Sixth Amendment therefore incorporates those limitations. The Supreme Court, speaking through Justice Scalia, went on to say that we do not read historical resources to say that a prior opportunity to cross-examine was merely a sufficient rather than necessary condition for admissibility of testimonial statements. They suggest that this requirement was dispositive and not merely one of several ways to establish reliability. There is further scant evidence in the English common law that exceptions were invoked to admit testimonial statements against the accused in a criminal case. Most of the hearsay exceptions covered by statements that by their nature were not testimonial, for example, business records, or statements in furtherance of a conspiracy. We do not infer from these that the framers thought exceptions would apply even to prior testimony. And Justice Scalia noted that one deviation they have found involves dying declarations. The existence of that exception as a general rule of criminal hearsay law cannot be disputed. In contrast, we consider reliability factors beyond prior opportunity for cross-examination when the hearsay statement at issue was not testimonial. Further, in discussing the concept of excited utterances, the courts noted that statements of a child victim to an investigative police officer admitted as spontaneous declarations that it was questionable whether testimonial statements would ever have been admissible on that ground in 1791 to the extent the hearsay exception for spontaneous declarations existed at all. It required that the statements be made immediately upon the hurt received and before the declarant had time to devise or contrive anything for her own advantage. The clause does not bar admission of a statement so long as the declarant is present at trial to defend or explain it. The clause also does not bar the use of testimonial statements for purposes other than to establish the truth of the matter asserted. And as another example, the rule of forfeiture by wrongdoing extinguishes the confrontation claims on essentially equitable grounds. It does not purport to offer an alternative means of determining reliability, and this concept was accepted by the Supreme Court in the Crawford decision. This slide pretty much reiterates what I have said. I'll leave it up for a moment so that you can read it. And this again reiterates directly from the opinion which I have stated just a moment ago. Now, some examples of non-testimonial hearsay that is still admissible under Crawford, depending upon the circumstances in each case. Davis versus Washington, the Supreme Court heard appeals in two cases simultaneously, and each of them considered testimonial statements and a definition. The first case concerned a state criminal defendant's trial on the charge of felony violation of a domestic no-contact order. Over the defendant's objection, there was admitted into evidence a tape recording of some pretrial statements made by a woman who did not appear at trial to a 9/11 emergency operator during a 9/11 call, including a portion in which the woman identified the defendant, her former boyfriend, as her assailant. And in the second case, it involved a state criminal defendant's bench trial on charges of domestic battery and violating his probation. Over defense counsel's objection, there were admitted into evidence a police officer's testimony and an affidavit by the defendant's wife concerning some pretrial statements by the wife who did not appear at trial to the officer at the asserted crime scene, the couple's home, after the police had responded to a reported domestic disturbance, where, after the wife had answered the officer's questions, the officer had her execute an affidavit. In the first instance, the Supreme Court held that the statements with respect to the 9/11 call are non-testimonial when they're made in the course of a police interrogation under circumstances objectively indicating that the primary purpose of the interrogation is to enable police assistance to meet an ongoing emergency, and only testimonial when the circumstances objectively indicate that there is no such ongoing emergency and that the primary purpose of the interrogation is to establish or prove past events potentially relevant to a later criminal prosecution. And obviously, the first situation involving the 9/11 call was upheld by the United States Supreme Court as being non-testimonial. In the other case, it was held to be testimonial in nature because a statement taken from the wife and reduced to an affidavit was in furtherance of the police investigation for prosecution and had nothing whatsoever to do with a pending emergency which the police would have to resolve. In the case of Giles versus California, the Supreme Court addressed the issue of forfeiture of right of confrontation. In so concluding, the Supreme Court stated that at common law, courts allowed the introduction of statements by an absent witness who was detained or kept away by means or procurement of the defendant. Cases and treatises indicate that this rule applied only when the defendant engaged in conduct designed to prevent the witness from testifying. The manner in which this forfeiture rule was applied makes plain that unconfronted testimony would not be admitted without a showing that the defendant intended to prevent a witness from testifying. The other exception that the question of domestic violence proceedings was the specific focus in the Giles case because the court concluded that acts of domestic violence are often intended to dissuade a victim from resorting to outside help and include conduct designed to prevent testimony to police officers or cooperation in criminal prosecutions. Where such an abusive relationship culminates in murder, the evidence may support a finding that the crime expressed the intent to isolate the victim and to stop her from reporting abuse to the authorities or cooperating with a criminal prosecution, rendering her prior statements admissible under the forfeiture doctrine. Earlier abuse or threats of abuse intended to dissuade the victim from resorting to outside help would be highly relevant to this inquiry, as would evidence of ongoing criminal proceeding at which the victim would have been expected to testify. The case in Giles was remanded so that the trial court could consider the intent of the defendant before introducing the out-of-court statements of the then deceased wife. So that rule does survive the Crawford decision, and it is essentially a common law equitable rule which brought that exception into existence. In Jackson versus the state, a Florida Fourth Circuit District Court of Appeals case in 2006, an individual by the name of Jackson was on probation for aggravated battery and was violated for an incident in which her fiance, the victim, called 911 for help. He told the dispatcher and later the responding officer that Jackson, apparently intoxicated, had rammed his vehicle with hers more than once and had hit him in the mouth. The victim did not testify. The evidence included an admission of a tape of the 911 call from the victim and a written victim statement given to the police. And the question before the court was, should the 911 tape have been stricken as hearsay? And the Florida Supreme Court concluded that the record supports the trial court's conclusion that the 911 tape was an excited utterance and not hearsay, and it described events as they were actually happening and was neither testimonial nor violative of Crawford in any circumstance. In Franklin versus State, the court looked at the nature of statements as to those which would render them testimonial versus non-testimonial. And opining, the court in Franklin stated that most courts agree that a spontaneous statement to a friend or a family member, such as the victim's statement to a friend Ellis, is not likely to be testimonial under Crawford, and indicating that a Colorado case, People versus Vigil, holding that an excited utterance a child made to his father and his father's friend immediately after a sexual assault was not testimonial, and statements made by a declarant in confidence and on his own initiative to close family members were not testimonial. And cases that say that an excited utterance made to a friend is non-testimonial. And a co-defendant's spontaneous statements to two different third-party acquaintances were not testimonial because they were casual, spontaneous, street corner statements. And furthermore, a statement made by a declarant to his girlfriend in their apartment implicating the defendant in a murder was not testimonial. And in general, comments to loved ones or acquaintances are not the kind of memorialized judicial process created evidence of which the Crawford decision speaks. Now, in this particular case, the victim spontaneously made the statements that had been admitted to his friend. He pounded on his friend's truck in order to summons assistance after he had been shot by the defendant, and to relay to his friend what had happened to him. He also made these statements in the midst of a medical emergency that he had just been shot and was struggling for breath. There is little doubt that the victim's excited utterances to his friend were not testimonial. There is also further case law generated under the Crawford decision in other states that hold that where statements were made to police in a non-custodial setting without indicia of formality, and while the victim was under considerable pain and distress, the statements could not be viewed by any reasonable person as being made with the expectation that they would be used prosecutorially and thus were non-testimonial. The police officer in this particular case indicated that his questions were directed to assisting in an ongoing emergency, and that the victim was under considerable pain and duress and was having difficulty breathing when he was responding to the officer's questions. And the statements were made shortly after the victim had been shot and before emergency personnel had even arrived on the scene. And finally, the Florida Supreme Court upheld a dying declaration in which a victim had made statements in response to a 9/11 operator's questions. They were not testimonial because they were made to enable police assistance in an ongoing emergency rather than anticipation to the trial. And in addition, the 9/11 comments were not testimonial because the victim was seeking emergency medical assistance for her life-threatening injuries. The Florida court went on to explain that an excited utterance is a statement relating to a startling event or condition made while the declarant was under the stress of excitement caused by the event or condition. Generally, to be admissible under the excited utterance hearsay exception, the out-of-court statement must be made while the declarant is under the stress of the startling event and without time for reflective thought. Now, that last series of statements describes the statutory exceptions to hearsay. And it's important to note that these lines of statements are not testimonial in nature. Therefore, the regular hearsay rules apply to that evidence, even though it's a criminal prosecution. Once the line is crossed into the testimonial hearsay realm, the Sixth Amendment Confrontation Clause kicks in, and any statements which were given when the defendant did not have an opportunity to confront and cross-examine the declarant are inadmissible, with one exception, and that is when the witness has been prevented from testifying by threats or violence, or in the case of the one decision, the murder of the victim to keep them from testifying. There was once a case in Maryland where two robbers armed with firearms went into a grocery store and locked the employees in the freezer. They then went about breaking into the safe, and later one of them said, "Let's kill these people, they're witnesses and they can identify us." And the other one said, "No, we can't shoot them because if we do, that becomes a capital case and we're eligible for the death penalty." The second person was able to talk the first person out of killing the people, and of course the people survived to testify against the two of them. But killing someone to keep them from testifying is a factual circumstance that has to be looked at by the court in individual situations. And keep in mind, some comments made by victims are excited utterances made when confronted by somebody with a weapon. So there are several different avenues to look at this type of testimony and this type of evidence. And the final analysis rests completely on the circumstances surrounding the giving of the statement. Now, a case that's more attuned to what we're talking about here with respect to scientific evidence is the case of Williams versus Illinois. And both FRE 703 and the Florida Rule 704 provide that if experts in a particular field would reasonably rely on these kinds of facts or data in formulating an opinion on the subject, they need not be admissible for that opinion to be admitted. If the facts or data are otherwise inadmissible, the proponent of the opinion may disclose them to the jury only if their probative value in helping the jury evaluate the opinion substantially outweighs their prejudicial effect. And the Florida rule basically tracks that to a certain extent, saying that essentially hearsay can be considered when experts render an opinion. Now, again, if we're in the pure opinion area, and we will discuss that in great detail in Module 14, the expert is testifying based upon information that was not personal to them, then they can use reliable sources to base their opinion upon. Because the underlying reliable sources have not been admitted into evidence, and although they are hearsay, they were used by the expert in making an analysis to reach an opinion. And this happens often in, for example, medical malpractice cases, which are probably not within the Sixth Amendment in any event, but they can be, and they can cross that line if it's involving a criminal prosecution, where a doctor can testify as to the cause of death by simply reviewing other documents that were submitted to them by police officers in investigative situations, by hospital records, and so forth. And it may be important in a homicide case to know some of this. The underlying factors supporting that expert's testimony are subject to cross-examination. But the Supreme Court in Williams versus Illinois said that nonetheless an expert relying on another set of tests can testify so long as that expert does not suggest that the underlying evidence is accurate. In other words, that they don't vouchsafe for it, only that they used it and their use was typical under the circumstances for that kind of evidence. Thank you, ladies and gentlemen, and that's all I'm going to say on these topics today.